Excellent. I will be passing it over to Grace to get things started today.
Thank you, Rachel. I'm going to share my screen. Can everybody see my screen?
Not yet.
Okay, it should be loading.
There you go. Yes.
Okay, cool. All right. Good morning, everyone. My name is Grace Phillips, a business advisor at CEI and program director at the Women's Business Center. Thank you for joining this webinar today. I'd just like to share a little bit about who CEI is and what we do for those who might not be familiar with our organization. CEI is a mission-driven financial institution. Many people know us best for our business lending and business advising services, which help entrepreneurs start, strengthen, and grow their businesses. Next year, CEI will celebrate our 50th anniversary of serving Maine communities. Just a snapshot of to highlight some of the impact of our work. Last year, we helped more than 100 businesses secure financing to start and grow their business. We deployed nearly $18 million in loans to businesses across the state. The majority of those loans went to businesses owned by people who are often underserved by the traditional financial system. We also provided one-on-one advising to more than 1,700 entrepreneurs at different stages of their business journey. We support for-profit businesses of all sorts. We also have in-house expertise and cross-functional teams focusing on several industry sectors shown on the screen here. I'm part of the CEI Business Development Services team, which is a mighty team of 10 on the ground working with entrepreneurs through one-on-one advising. We help businesses get started, access financing, grow, and prepare for transitions into their next phase. We also offer workshops and trainings that address the everyday questions small businesses face, including the webinar you are joining today. Some of our programs run longer, from 4 to 12 weeks, and are designed to build community while creating opportunities for peer-to-peer learning and support. You can scan the QR code here to see our upcoming programs. Rachel can also share the links in the chat so you can bookmark them for later. All of these services, whether advising or workshops, are offered at no cost to participants. Most of our workshops are recorded. Even if you can't attend live, you will receive the recording and material afterwards as long as you register. We are also one of the major hubs for Maine's women-owned businesses through our Women's Business Center program, where women can learn new skills and build connection. Another easy way to access our services is through Ask an Advisor. Whether or not you are already working with a CEI business advisor, you can drop in on Zoom every Wednesday from noon to 1 p.m. if you have a quick question. 2 business advisors are always available, and the format is flexible. There's no commitment, so you can just join when you need support and hop off when you are done. Simply go to our program page and register for the next session to get the Zoom link. With that, I will stop my share and pass the mic to Parker.
Thank you so much, Grace, for that. And I will also share my screen and a little slideshow to introduce MITC. Let's see if it's kind to me. Okay. Do we see it? Excellent. So my name is Parker Dinsmore, and I'm an international trade specialist with the Maine International Trade Center. Always a mouthful. So we are Maine's leading source for international business assistance. And that looks differently depending on how you interact with us. So I'll get to that momentarily, but just a quick background on our org. we are so lucky to be partners with CEI, and similar to them, we do help small businesses in Maine get their foot in international business. So we are part of the Department of Economic and Community Development. So that means we're partly state funded, but we're also propped up by membership dues, which play a big part in our organization. So you can see this is our team, by the way, in the photo. That was at our annual trade day event, which was a couple of weeks ago. So what does trade mean for Maine? We're a small state, but trade packs a punch here. So in 2024, Maine exported $5.5 billion worth of goods and services. 84% of Maine exporters are actually small and medium-sized businesses. So while we do work with the IDEXs and LL Beans of the world, we actually mostly work with our small to medium-sized businesses who are our clients. And in fact, international trade supports 1 in 5 jobs in Maine, which is always a cool, fun fact. And then, as you would expect, the top country employers are the Netherlands, Canada, and the United Kingdom. And then also foreign-owned companies are employing about 36,800 Maine workers. So quite a significant amount. I'll just jump ahead here because I do want to highlight our membership and also shout out. We actually have a member on this webinar, Cole Trosclair with CH Powell. She's been a tremendous resource for our companies who have questions on this very topic, tariffs. So we're a member-based organization. We have over 200 manufacturers and service providers, educational institutions, industry associations, and also even economic development partners. So while we work with both exporters, importers, we also make these industry connections throughout the state. We have events that are really cool. We actually have some coming up in July in the blue economy. So if that interests you and meeting Maine businesses and being plugged into our network, you should definitely look at our website and check it out. And I will again reiterate that 63% of our members are fewer than 25 employees. So that really gives you the idea of like Maine. When you think about trade, it's a lot of small businesses. And so how we help companies, it really depends, but our bread and butter is the one-on-one business assistance. So as trade specialists, myself and Abby Plant, who's the senior trade specialist, and now our newest one, Peter Rousey, we help businesses with customized research requests. So oftentimes this is, hey, Parker, how do I export to Chile? And while I can give a quick market analysis, the cool thing that we do is with our network of international business development consultants overseas, I can actually go to them and say, well, hey, I can put you in touch with Paul from IBG Global, and he'll actually go out and make those connections for you. And not only that, but with our STEP award, which is actually an SBA grant that we work with, we can reimburse up to $10,000 of that project. So if that is something that you're interested in, I would highly recommend reaching out to me because that is a very cool thing that we do for companies. And of course, this is going to be my segue into the presentation because while you might think that we primarily help exporters, but over the past year, our number one request for assistance, you can guess what it is. It's tariff and tax rates. So the question I constantly get is, Parker, what duty am I paying on this product? And that's why we're so grateful to have a member network and actually have Sandler, Travis, and Rosenberg as a resource, and Mark Segrist, who you'll hear from in just a minute, to help companies with these questions. Because for small businesses who aren't the IDEXs and LL Beans of the world, this question is even tougher to solve, and it's not always easy. So we're really grateful to have this network that we can help answer these questions. And I mean, to say that it has been a turbulent time in the trade world is a massive understatement because we have IEEPA refunds and then the 122 tariffs that replaced that. And now, as you'll hear, even potentially more tariffs on the way. So with that, it is my pleasure to introduce Mark Segrist, who's a partner at Sandler, Travis, and Rosenberg. I consider him to be an expert in this topic. Thank you very much for joining us, Mark. I'll pass it over to you.
Thank you very much, Parker, and thank you to MITC and to CEI for kind of including me on this. Hopefully, I will be able to share my screen properly here. Let me see if I'm able to do that. Please let me know if you are unable to see it. Is it small?
It's perfect.
It's perfect. Okay, so hopefully everybody can see that all right. If there's issues, please let me know. But thank you for the kind introduction, Parker. As he mentioned, my name is Mark Segrist, and I'm a partner here at Sandler, Travis, and Rosenberg. We are a boutique international trade law firm in the sense that that's all we handle is customs, international trade, import, and export. But we are the largest customs and international trade dedicated firm, I believe, in the United States, if not the world. We have offices throughout the United States in New York and DC and Miami and San Francisco. We also have offices in Asia and Hong Kong and Guangzhou, and strategic partners in Mexico and Canada and Europe and kind of all over the place. And so I'm really happy to be here. There is a lot to cover today, and so I'm going to do my best to go through these slides as quickly as possible. Some folks on the presentation may be very familiar with these topics. Some folks may be relatively new and kind of just know the buzzwords. If you have questions, feel free to reach out to the folks at MITC or CEI or myself, and we can get you the guidance that you need here. But a little disclaimer here, there is a lot moving every single day. There are new proclamations, there are new executive orders, there are new movements on investigations. And so some of these things are as good as basically they are said today. So keeping that in mind, I want to talk very briefly about a couple topics here. First and foremost, I want to talk about the IEEPA refunds and the CAPE refund process, because that's the question that we're getting a lot from folks is, hey, I heard that these tariffs were overturned. How do I get my refunds back? So I'll start with that. I'll then parlay into the Section 232 tariffs. Now, these are different than the IEEPA tariffs. These are the ones that are more national security oriented. So when you think of steel and aluminum and copper and timber and all of these other things, those are the tariffs there. I will also, if we have time, talk very briefly about the Section 301 tariffs, which maybe you remember back during President Trump's first term. Those are the tariffs that he used to impose tariffs on China. Those are kind of coming back again, partially to replace some other tariffs that may be going out due to court rulings. I will also talk about the Section 122 tariffs, as Parker maybe alluded to earlier, that are really kind of replacing the IEEPA tariffs, but only for a short period of time. And then again, if we have some opportunity here to talk about tariff mitigation strategies. So let's start with the IEEPA tariffs. IEEPA stands for the International Emergency Economic Powers Act. And so this was a statute that was granted by Congress and gave the president the authority to regulate trade during moments of emergency. And so he utilized this statute basically as one of his tools to impose a variety of tariffs on pretty much every country in the world. He started with imposing tariffs on fentanyl, due to fentanyl on goods coming in from the Canadian and Mexican borders. He then also put tariffs on Chinese goods coming into the United States, again, under the auspices that fentanyl was being shipped to the United States. He increased the China tariffs to 20%, and then he imposed these 10% reciprocal tariffs that basically applied to every country in the world. If you can remember on that, I think it was April 2nd, it was known as Liberation Day, where he came out in the Rose Garden. He had that list of all the different country names and the different tariff rates associated with them. Those were imposed then as well. He also imposed 40% tariffs in addition to the 10% reciprocal tariff on goods coming in from Brazil, and then also Indian goods due to the purchase of Russian oil by India. So there was quite a smattering of tariffs that were imposed on all countries in the world. But in February of this year, the Supreme Court ruled that the president does not have the authority to impose tariffs under IEEPA. They basically made relatively clear that IEEPA gives the president the authority to regulate foreign commerce in the face of an undeclared or a declared unusual or extraordinary threat, but it did not give him the authority to tax or put tariffs on imports, which effectively is an Article I power delegated to Congress under the Constitution. So those tariffs were struck down, but what does that mean? Well, basically it means that the president never had the authority to impose tariffs under IEEPA, and all of the IEEPA tariffs are unlawful. So not just the fentanyl tariffs or the reciprocal tariffs, but also the Brazil and India tariffs. Long story short, any tariff that was imposed through the tool of IEEPA, that statute, was ruled unconstitutional, and as a result, refunds were needed to be given. So that raised this question. If you happen to read I think it was 72-page opinion, at the very end, there was some statements by Justice Kavanaugh in his dissenting opinion, basically saying, well, nothing in this decision really talks about how refunds are going to be given to anybody. We just ruled on the constitutionality of this issue, but the refund process is, quote, likely going to be a mess. That's kind of how that ended. But since then, and through court orders, there have been a variety of status updates. I'm not going to go through all of these. They've actually even changed slightly since I started putting these slides together. But the big ones that you need to know is March 4th, Judge Eaton, who is the judge at the Court of International Trade that has been assigned this case, basically said that CBP must immediately refund IEEPA tariffs to folks. And Customs and the Department of Justice have been giving updates pretty much every couple weeks since that time, talking about the creation of this CAPE process, the consolidated, I'm trying to think what that stands for. I can't remember the acronym off the top of my head, but it's basically how they are going to be processing the refunds for IEEPA tariffs to importers. Customs has come out and the Department of Justice has come out and said that they've, processed over $35 billion worth of refunds to importers through the CAPE process. And we are seeing a lot of our clients actually start to receive refunds in the door, which is great news, but there's still a lot left that's unknown. And so I think one message I want to get across to folks is it ain't over until it's over here. And you need to continue to watch these court cases because the Department of Justice is going to continue to appeal these. And so that's going to kind of burn out more and more of the clock. And there are steps that I think importers need to be very aware of as they move into that process so they don't let certain entries kind of slip beyond certain procedural deadlines and they can make filings for refunds. So let's start just kind of at a high level here. Who is eligible to file a refund in the CAPE system? I guess let me back up just a little bit. The CAPE system, is set up inside of ACE. And so ACE is another acronym that stands for Automated Commercial Environment. And so when you're an importer of record in the United States, you file entries through ACE, which is kind of an online portal with U.S. Customs and Border Protection, where you file all of your entry data, all of your entry summary information is kept there, and there is within ACE a CAPE tab where you can kind of go in and you can start to apply for refunds if you paid the IEEPA tariffs. And so for those on the call today, if you don't have an ACE account or if you don't have access to your ACE account, that's really step one, because it's going to be really difficult for you or your customs broker to file a refund request if you don't have access to your data. So who is actually eligible to file? Importers of record. So if you were the actual importer of record of the goods, you could file a CAPE refund request within ACE. Licensed customs brokers who file the entries are also eligible. So if you used a customs brokerage firm to file your entries for you, which most companies actually do, they could also file these CAPE refund requests on your behalf. Now, we know who is eligible, but the next question is which entries are eligible? So this is really where you get into kind of the nuts and bolts of customs law and how long entries remain open in the system or unliquidated in the system. But generally speaking, when an entry comes into the United States, it is open or unliquidated for about 314 days. And so, if an entry came in on day one, you effectively have, under most circumstances, an entry that remains unliquidated for that 314-day period. It's about a 10-month period. And so if you have, recent entries that have not liquidated, or they are known as being unliquidated because they're within that 314-day period, you could file a CAPE refund request, requesting refunds for tariffs paid on those entries. Customs is also allowing companies to file a CAPE refund request for any entry that has liquidated, but within the last 80 days. So kind of playing into that 314-day liquidation cycle I just talked about. If you have an entry that comes in on day one, it will, again, assuming it's a normal liquidation cycle, will remain open for that 314-day period or unliquidated for 314 days. But on day 315, for instance, that entry could liquidate or become finalized within the customs system. And then you have 180 days from there to file a protest with customs if you need a way to get to court or preserve your rights to refunds. But customs has basically said, well, hold on. We will allow you to file a CAPE refund request for any entry that is unliquidated, as well as any entry that has liquidated within the last 80 days. And so it's a little bit of a stacking system that they have there. So it's really important to get your import data, your ACE data for us or whoever you're working with, your broker, to be able to see the date of the entries, what the entry dates were, what the liquidation dates were, because at a certain point, entries may be so old that they are ineligible for CAPE, and you have to use some other alternative means for achieving a refund. CAPE will also accept but not immediately refund or liquidate entries if they are suspended or extended or under review. Sometimes warehouse or warehouse withdrawal entries liquidate much more quickly. And so it's important to kind of track those dates as well. And I will be available for questions at the end of this, but I just want to try to get through some of these slides. And I know that's a lot to kind of think about. What I'm trying to convey here is that CAPE by itself, even though it's this governmental system that has been set up to process refunds, is just that. It is a governmental system that was developed by U.S. Customs and Border Protection. It does not have the force of law, right? It's not a statute. It is not case law. And so it's important to keep that in mind and make sure that you're following the legal track to make sure that you're entitled to refunds. Because CAPE Phase 1 right now will not process any entries where liquidation is final, right? It's past that 314-day period and past the 80-day period I talked about. Some companies flag their entries for reconciliation for a variety of reasons, which I could talk about ad nauseum. Some companies have filed for duty drawback, right? Maybe they imported something and then they exported it up to Canada. Those claims are not eligible for CAPE. Some companies have already protested maybe a classification or a country of origin of a product with customs. If there is a protest sitting on an entry, that entry is also not eligible for CAPE. If you don't have a liquidation status in ACE, it may not be eligible. Some products are also subject to anti-dumping or countervailing duties, for which there's not really a final rate yet determined by Commerce. And so those are also not eligible for CAPE. And so you can see that there's this large loophole or gap where certain entries may not be filed in the CAPE system. And so I really want importers to know that if you can use CAPE, that's great. We're happy to help you with that. But keep in mind that certain entries may not be eligible, and you need to make sure you're preserving your rights to potential refunds if you don't have that. Now, this is just a slide talking about that the Department of Justice has indicated that they do plan on creating subsequent phases of CAPE to be able to handle all of those other issues we were just talking about. But the concern is that we don't know how long that's going to take. And if that takes such a long period of time that your entries have now liquidated and are beyond the 180-day protest filing period, which is based on law, you could be sitting in a situation where you didn't file a protest because you were kind of hoping and praying that CAPE Phase 2 was going to be created and that was going to mop up your entries, but maybe it doesn't. And then, we just don't know how that's legally going to be playing out. So I really want folks to be cautious of their entry dates, their liquidation dates, and which bucket your entries go in. Do they go in CAPE Phase 1? Do they go into CAPE Phase 2? Are you filing a protest? This is kind of the point I'm making here. Will CAPE solve all of my problems? I think if you have relatively recent entries and all of your entries are unliquidated or they've liquidated in, fewer than 80 days ago, CAPE might be all you need. So you could log into ACE, upload the list of your entries in CAPE, and you may get all of your refunds back that way. But this is a new system that's being used by tens of thousands of importers as well as customs for the first time. And the government can still appeal Judge Eaton's April 7th order in Euronotions, which is kind of the lead case here, granting universal relief. Universal relief means it applies to all importers, anybody who paid the IEEPA tariffs. The government has made it relatively clear that they do not want the ruling to apply to all importers universally. They want the ruling to apply to only those individuals who were plaintiffs in the case. And so this leads to another topic, which is, do companies need to file their own lawsuit at the Court of International Trade, which our firm has been helping quite a few people with, but we will get there. So this, for folks who are able to take this home with them and get copies of these slides, the boxes in green are really what we know now, right? Importers of record are able to file in CAPE. Licensed customs brokers are able to file. Entries that are unliquidated are eligible for CAPE, and entries that are up to 80 days post-liquidation are also eligible. In the middle column there, you can see this is really what you need to be able to do to access a CAPE filing and to be able to make that CAPE filing. First and foremost, you need to create and log into your ACE account. So I would highly recommend Googling that or looking up how to access your ACE data, because if you are an importer of record, Customs does have that data. They have access to your information. But the question is, do you have access to your own information to be able to run reports? And so it's then at that point, following the process, filing the CAPE declaration within ACE, and making sure that all of your entries don't error out for one reason or another, which I'll talk about, to make sure that you're getting all of your entries submitted in the CAPE and that they have been approved, and that hopefully once it's been approved, refunds will be issued within 60 to 90 days following that. So this is kind of a decision tree where we are seeing quite a few entries error out for clients. Once you're in ACE, if for some folks are aficionados in ACE, we have an entire ACE team here at the firm that is much more educated on this than I am, but there are quite a few reports, canned reports that you can run within there, kind of that come out as spreadsheets. The ES 022 report basically tracks your entry summary report at a high level. You can also access a Revs 603 report that kind of shows which entries are involved and whether the money has actually been sent to the Treasury, meaning that Customs has kind of approved it and the money's kind of in the flow to get back to you as an importer. Those are helpful reports. There's also the Rev 615 report that is really dialed in more on an entry by entry summary level as opposed to kind of a consolidated report, and shows that when funds or declarations have been sent to Treasury. And then the Rev 613 report. This is really important because Customs has made clear that they will not issue a refund to an importer via check, or they're not going to mail you a check. This has to be done via ACH. And so companies need to make sure they're getting access to their ACE account, number one, and number two, that they have signed up for ACH refunds electronically through their banks here in the United States. Because if you don't, it may be rejected, and this report kind of helps you show that. The next few slides I'm going to breeze through really quickly because these are just errors. You can see on the left side, these are just different error messages that have come up to us through our clients saying, I'm unable to upload this for one reason or another. On the right side is kind of the definition or how it's been translated. I'm just going to highlight a couple. Sometimes files are deemed unsafe. You'll get an error message. You need to resave and file it and upload it again. I'm just sharing these with the hope that folks are going to be able to get a copy of these at some point. But if you need a copy, feel free to email me after this as well. I can send you one. Again, just different error messages that we see on the left side and how they're defined and how you can kind of remedy them on the right side. You can see there are quite a few. And so we get a lot of frantic clients reaching out to us saying, I have, $1 million in refund here that is not being processed because of this error message that I've received. So this is just kind of a translational chart to kind of help show you those different error messages and how things can be remedied. There are quite a few of them, but I just included this just in case it was helpful. So to summarize here on the IEEPA tariffs, it has been a little bit of a circus trying to track this throughout the process, but I think the things that folks need to be doing, you need to be watching the Court of International Trade or following publications like maybe our firm or MITC puts out, just to see how the court is going to rule on the CIT. I know the Supreme Court has said that they are unlawful, but now the process is how do you refund those funds back to importers? Does it apply to all importers or just the people who filed suit? Does it apply to all entries or just finally liquidated entries or unliquidated entries? You need to kind of monitor the Court of International Trade to see how they are going to process those. You need to track your entries and noting that protests are due within 180 days of liquidation. Keep an eye out for your phase one refunds. And then my legal recommendation here is that if you've submitted your entries into CAPE, if you are due for a refund, but you have other entries that were too old or one reason were rejected out of CAPE, you should really consider filing a protest within 180 days of the date of liquidation to preserve your rights to refunds and potentially even go to court if you need to. I'm hopeful that none of that ends up needing to happen for companies, but many of our clients have multi-million dollar amounts that are at stake. And so for them, it's kind of a belt and suspender approach. And then finally, you can also consider filing a refund suit yourself if you have entries that are kind of outside that protest window. Just want to see how we're doing on time. I've got a little bit more to cover here. So we are now pivoting from IEEPA, the emergency statute that the president used that has been deemed unlawful, to now the national security related tariffs, the Section 232 tariffs. So this is based on a completely different statute, and there are a variety of Section 232 tariffs that are in place that have been changing frequently as well. I've got to go through this relatively quickly, but I'm hopeful that folks will be able to reach out or follow along. But on the left side, you can see these are the different types of products where right now we have Section 232 tariffs either in place or currently under investigation, where they're negotiating what those specific rates will be. But you can see these are things that the government has deemed in the national interest, national security interest of the United States. Steel, aluminum, and copper, timber and lumber products, automobiles and automotive parts, medium and heavy duty vehicles, semiconductors, critical minerals, which are still in negotiations right now, and then pharmaceuticals as well. The rates are really all over the board, but I would say kind of, anywhere from 25 to 50% is kind of where most products are falling. Pharmaceuticals obviously has kind of that headline grabbing 100%. There's some specifics to that as to whether that applies to all companies. But steel and aluminum is probably the highest mid-range at about 50%. There are exceptions, as you can see on the right side. So it's all going to depend on what the country of origin of those products are, where they're coming from, what their content is to a certain degree. For automotive and automotive parts, whether they qualify for the USMCA free trade agreement is a relevant factor. And for vehicles, for instance, it's just only applies to the non-US content of a product. And so once you determine, which bucket your product falls in, is it subject to the Section 232 tariffs, or is it subject to Section 301 tariffs, which we'll talk about as well, then you try to figure out, are there exemptions available for particular products? But hopefully this chart is helpful to kind of show you where we are. I want to spend just a second, because this was a big question that we were getting a lot for the last year. Prior to April 6th, so, a month and a half ago, 2 months ago about, if your steel or aluminum or copper was smelt or cast or melt and poured in the United States, it was exempt, right? So even if the product coming in was produced in another country, if the steel came from the U.S., melt and pour or smelt and cast, it was exempt. Everything else was subject to a 50% tariff on the metal content only. And it was also exempt if it didn't contain any subject metal, or if it was for civil aircraft parts from the UK, EU, or other countries. Those were exempt. But what happened is that underlined portion right there in the center that says on the metal content was something that was strategically analyzed by legal teams and companies to try to figure out, what does that actually mean? How far back in the supply chain can we go to get the true raw value of that metal or steel or aluminum? I think customs started to pick up on that and started to feel like this was an area that they were going to be perhaps unable to enforce. And so things changed. And on April 6th, the rules changed. And basically it's on the full value of the product, regardless of whether, there's a certain level of steel or aluminum or copper. There's also a 10% now tariff on even goods coming in that have U.S. smelt cast or melt poured items. But the buckets of how these have been separated are really into these three different annexes now. And so Annex 1A is really 50% tariffs on all countries with certain exceptions. Annex 1B is 25% tariffs on all countries with certain exceptions. And then Annex 3 is kind of the lower 15% tariff on all countries with also certain exceptions. And so this is going to be based on the HTS code, the classification of the product. And so it's important to know that if your product is subject to these Section 232 tariffs, you know what the HTS code is, and you know which annex you kind of fall into. Because there are exceptions here too. If your product doesn't contain any of the subject metal, it's not subject. If the aggregate metal weight is less than 15% and the product is classified outside of certain chapters, it also is not subject. And if it's a motorcycle part or a civil aircraft or part from certain countries, it is also exempt as well. So this is a lot. You could do an entire presentation just on Section 232 tariffs, but I wanted to highlight that. Another thing that they've changed here is that the public inclusion process, which was really a process where companies could come and say, hey, my competitor's bringing in this product and I want this on the 232 list to kind of put us on a level playing field. They got rid of that. They basically said that the U.S. trade representative in the Department of Commerce have the authority to just do this on their own. And they will publish these and they will let you know when they've included other products when they deem appropriate. Some things folks need to keep in mind is that certain classifications under Chapter 98 may be eligible to ensure that you are not subject to the 301, or excuse me, to the 232 tariffs. And so I'm thinking, for instance, like agricultural and horticultural machinery. We have a lot of clients that are bringing in things that technically, are parts of an agricultural or horticultural piece of machinery or equipment. They have the ability to potentially classify those products under Chapter 98. And as a result, those may be exempt from the tariffs as well. There are certain ways that you can claim back the 232 tariffs if you are exporting the goods and claiming drawback. But you can see here, there are quite a few lists of requirements that you need to comply with before your goods actually qualify for that drawback claim back. There's also an opportunity now for companies in Mexico and Canada, for instance, if they're supplying steel or aluminum to the medium to heavy duty vehicle market, they may be able to be eligible for a reduced rate of duty and not be subject to that higher 50%. But again, this is going to be something where you're going to need to demonstrate that the steel that you're getting or the aluminum that you're getting is for that industry from those regions. Here's a little bit of a summary chart talking about what we've talked about so far. You can see on the left-hand side are all the different how the tariffs apply to the different types of metals. In the middle column is kind of how it was interpreted prior to April 6th. And I leave this in here because it's still relevant, because some companies made entry prior to April 6th and paid duties based on a different interpretation. And so the question now is, do you have legal support for that interpretation? And are you able to continue to claim only paying the tariffs that you paid based on that amount at that time? But on the right side, you can see the summary of kind of how the tariffs are applied. You can see the top line here is the Section 232 tariffs used to apply to just the value of the metal content, and now they apply to the full value of the import. And then, as I mentioned, you've got your different kind of ranges of the 232 tariff rates all the way through. There are also, not to overwhelm everybody here, but there are also 232 investigations on a variety of other products. So not just the lumber and the steel and the aluminum. There are 232 investigations on commercial aircraft and jet engines, polysilicon, drones, wind turbines, robotics, and personal protective equipment as well. And so this is really a thing where having a resource like MITC or our firm or CEI or someone else, whoever you're working with, is really important, because there's just a lot of moving parts and you never know kind of what product you may be importing and whether it may be subject or swept into one of these investigations at some point. Okay, so just to level set here in the last few minutes we've got, we've talked about the IEEPA tariffs and how those are the emergency tariffs that have been struck down by the court. We've talked about how it's really important to get access to your ACE data, to track those entries, to submit a CAPE claim, and to file protests where appropriate. We've talked a little bit about the Section 232 tariffs, which are not being challenged in court. I guess they are to a certain degree, but not substantively on their merits, are not being challenged in court. We're now pivoting a little bit to the Section 301 tariffs, because these are the tariffs. This is, again, a different statute that the president used to impose tariffs on China back in 2018, if you all can remember back that far. These are kind of going to be the new tariffs that are coming into place to replace the, confusingly, Section 122 tariffs that the president put into place the day that the Supreme Court struck down the IEEPA tariffs. And so we'll talk about the 122 tariffs, but basically when the IEEPA tariffs were struck down, the president came out into the press briefing room and announced that he was putting 122 tariffs in place until such time as kind of 301 investigations or 232 investigations could be completed. And so the 10% Section 122 tariffs that are in place right now are going to expire in July next month. And these types of tariffs are probably going to be taking their place. That's my prediction there. And these deal with a lot of different things. So you can see the underlined section here is that the president and the trade administration are focused on industrial excess capacity, forced labor, pharmaceutical pricing practices, discrimination against U.S. technology companies and digital goods and services, digital services taxes, and like the big social media platforms and e-commerce platforms, ocean pollution, and practices related to the trade in seafood, rice, and other products. So this is a pretty broad net that they are casting here to conduct Section 301 investigations on companies. Here's a little summary of this. On the left, you can see the investigation that has been kicked off, right? So at the top, you've got structural excess capacity and production. The president is focused, and the U.S. Trade Representative are focused on 16 different economies there. It was initiated in March. Failure to impose or effectively enforce prohibitions on forced labor, for instance, that covers 60 different economies. And you can see down the list, there are all these different Section 301 investigations that have been announced that will, over time, conclude their investigations and then likely impose tariffs as a result on certain products from certain countries. And you can see I was traveling this weekend, but I had to include at the very bottom here in red, just this weekend, there was a new Section 301 investigation on Vietnam, kind of tracking policies, acts, and practices related to IP protection, which is very similar to what the president used when they imposed tariffs on China back in 2018. So a lot of moving parts here. Just a quick summary here. This is talking about the manufacturing capacity 301 investigation. The countries are listed there: Bangladesh, Cambodia, China, European Union. Again, it covers quite a few different countries. Same with this slide. This is talking about forced labor. The 301 investigations are focused on all of these different countries where they are concerned about forced labor being utilized in the supply chain. So we'll have to see how those investigations play out. And I wanted to bring that up because those 301 tariffs will likely replace these tariffs, which these tariffs are the Section 122 tariffs. They have already been challenged. They've gone to court, 24 states, including Maine. And 2 importers have sued the Trump administration, challenging that this was not a balance of payments issue, which is Section 122 is required to be a tariffs imposed to fix a balance of payment issue. And the court basically ruled that Section 122 tariffs are unlawful in a 2-to-1 split. Again, they were just making the argument that Section 122 was not the correct statutory provision to impose the tariffs that the president sought to impose. This is still being decided, right? So the government had filed for a stay. They've issued a permanent injunction only as to the named plaintiffs. So the named plaintiffs are not required to pay those tariffs, but for everyone else, these tariffs are still in effect, right? The government is obviously arguing that this should not be a universal injunction. It should only apply to the named plaintiffs, and they are appealing this right now. The government has appealed it to the Federal Circuit Court of Appeals, and the Federal Circuit has granted an administrative stay of the CIT judgment until further notice. I do not see personally this case moving as quickly as maybe the IEEPA tariffs moved to the Supreme Court for 2 reasons. Number one, summer recess is happening soon with the Supreme Court. And number 2, these tariffs by statute are set to expire in July. The IEEPA tariffs, for instance, could have stayed on for indefinitely. And so I think there's a little bit more of a natural clock here that will run out. And so I will just have to kind of watch this space to see how that plays out. But monitor the 122 case. Again, track your entries. This just gets back to the ACE data thing, because you may need to go through the entire same process you did with IEEPA if and when the Section 122 tariffs are struck down by higher courts. And so you may need to file protests. Customs may even recommend using the CAPE process again. So thankfully they have that portal set up. Very lastly, in my last 2 minutes, a couple mitigation strategies. First sale, if you have a chance to look up this is something I help run our first sale practice here at the firm, but it gives an opportunity for companies who are subject to tariffs to potentially use a lower price at the time of importation. So if you are an importer of record, you're buying from some seller, maybe located in, I don't know, France or Hong Kong or somewhere else, but they are actually not the manufacturer and they're producing the goods from a manufacturer behind the scenes. You may be able to utilize that lower middleman to factory price at the time of entry, and tariffs would be assessed on that based on the higher middleman to importer price. Free trade agreements, we're starting to see that certain free trade agreements, such as USMCA, are benefiting importers who are subject to like the 232 tariffs. And so trying to figure out how to reshore your products or produce them in a way that they qualify for preferential treatment under maybe USMCA or some other free trade agreement that the United States has may benefit you in the long run by getting more preferential rates of duty at the time of import. We can certainly help look at those products for companies. I'm sure MITC can do that as well. Tariff engineering is a big one too. Can you reclassify your product to potentially qualify for an exemption to one of the tariffs? I brought up the agricultural and horticultural use equipment stuff under Chapter 98, but there may be ways to partially or fully avoid duties if you can reclassify your product in a different provision, kind of known as tariff engineering. And then finally, foreign trade zones and bonded warehouses are also ways that companies are, if not completely avoiding the tariffs, they are at least deferring the tariffs. And so there's a cash flow benefit potentially by bringing your goods into a foreign trade zone, which is not subject to tariffs at the time of admission or withdrawal, depending on where they're being withdrawn. And bonded warehouses as well are an option for folks. So that was a lot. I want to leave some time for questions. Parker and team, take it over from here, but I will I guess stop sharing my screen now and we can open up for questions.
Thank you, Mark. That was really great. I mean, it's a lot of information, but you covered it all so well in such a short period of time. I see we had a question while you were presenting from the audience, and it was, if an importer broker paid the duty and passed the charge on to a business it purchased imported products for, does the broker then pass the refund back to the business if they're successful in getting the refund?
That is a really great question. And unfortunately, it's going to depend, and it sounds like a legal answer, but it's going to depend on what the legal documents were, like the purchase agreements or the purchase and sale agreements or terms and conditions were between the importer and the downstream customer. Some of our clients are, we're very clear that, they're passing tariffs along and they kind of line itemed the tariffs on the invoice when they sold the goods downstream to the US customer. And so as a result, the US customer is coming back and claiming, hey, we paid the tariffs. Ultimately, you need to refund us if you are receiving a refund. But there's kind of two schools of thought here. One is a legal answer, meaning are they legally required to refund those tariffs to the downstream customer? And that's going to be dependent on contracts and agreements and whatever the agreements were between the parties. But then there's the larger practical business side question, which is, we have a lot of clients that say, legally, I'm not required to pass these tariffs along based on the terms that I had, but this is an important customer to me. I want to keep them happy. And so we're going to split it, or I'm going to do a certain thing for them and I'll offset it based on what my expenses were to get those. And so it's going to really depend on the details of the fact pattern.
Any other questions from the audience? And if not, I have some questions for you, Mark.
Sure.
Oh, I see one from the chat. Great, 2 questions. I'll start with Abby's. Have you heard anything about seafood 301 investigations?
Yeah, I know that there's obviously an investigation. It just started. We don't have, usually a Section 301 investigation takes close to a year, right? I mean, when this first started back with China back in 2018, the US Trade Representative would announce this investigation. They would conduct studies, there would be hearings, there would be an opportunity for folks to comment. And so I think for the seafood side, I could get you the specifics as to kind of what the timeline is, because there are going to be hearings, there are going to be opportunities for folks to submit comments. But I would highly recommend, if that's going to affect your industry, that you get involved and you submit comments. We have a lot of clients that submit comments directly to the Department of Commerce or to the US Trade Representative. Some of our clients even testify up on the Hill when there are those congressional hearings. And so, just track that, because it is in the investigation stage. And so you really want to try to get involved as best you can to kind of shape where that investigation goes, if you can, along the way. But we don't know anything in terms of what the specific rates are going to be on that just yet. It's too early.
Great. And then another one from the audience. I would think most small businesses use a customs broker to import goods. If so, should they start by going back to that customs broker to ask about refunds? If that small business did not use a customs broker, could they now hire one to help with relief?
Yes. So most small companies I would envision utilize the services of some type of customs broker. It depends on the value of the shipment. But it's a complicated process, and a lot of companies don't file their own entries right away, and some do, but many companies use a broker. And so if you used a broker, I would highly recommend you reaching out to them, because they will have all of your import data, right? They would be able to help you run ACE reports from their account, showing all of your entries that you made, the dates of entry, the dates of liquidation, so you could track protests, you could track CAPE filings. Highly recommend that. If you did not use a broker and you need assistance now, you could certainly reach out to a customs brokerage firm to see if they would be willing to help you submit a CAPE declaration. You can also do that on your own by accessing your own ACE account, but you could certainly ask them. I know some brokers are more willing to do that than others. Some, if they say, if I didn't file the original entry, I don't want to be part of any post-entry submission or filing with customs. But it's just going to depend on who the broker is and whether they're willing to do that.
All right, so I have a question for you on the topic of the 301 investigations. It seems to me like with the 122s expiring, as you said, that the administration will hope to do some kind of broad tariff to all the economies that you mentioned in that slide. Do you think that because 301 is under a different legal framework than the IEEPA tariffs, that challenging those future 301s will be more difficult or next to impossible or the same? What do you think?
Yeah, I think it is a different game when we're talking about 301 tariffs or 232 tariffs than when we were talking about the IEEPA tariffs. And so I think the reason is that the president used this really, really powerful tool out of the congressional toolbox. And he said, I'm going to call everything an emergency, right? We have a trade deficit with this country. It's an emergency. And I can raise tariffs today. I can drop them tomorrow. I can raise them again the next day. I can drop them tomorrow, which the courts have really, and Congress, frankly, have really taken issue with. And so that's why I think those were struck down so quickly, is that it's relatively clear constitutionally that taxing and spending should be with Congress, not with the executive branch. And so IEEPA is very different, though, than Section 232 or Section 301, which give really clear delineated rules that you need to conduct an investigation. You need to kind of hire economists. You need to figure out what the harm was to the U.S. economy, or you need to figure out, is there a national security interest here for the U.S. government? And then once you've made that decision, once the president has made that decision with the USTR and they've gone through those procedural due process steps that are outlined in the statute, I think it's very difficult to challenge those on constitutionality grounds, because the argument would be that, hey, Congress gave me the authority to do this. We followed the steps. We checked the boxes. We did everything we needed to. We are in court right now still challenging the 301 tariffs on China, but not lists 1 and 2. We argue that those were done correctly. We're challenging lists 3 and 4, which we think were done much more quickly outside of the bounds of that statute. So I think these are here to stay if they're imposed, I think, for a while.
Great. And then I just want to go back to an earlier point you made. We have a licensed customs broker, Cole, who said a broker can only submit CAPE declarations for entries that they filed. We cannot submit CAPE declarations for files that other brokers submitted. I guess that would answer the previous question on if you were a licensed customs broker who did not file entries. I guess that means they cannot. Then
that's correct. That's correct. I have heard people take discussions offline and move somewhere else with another broker and start talking about it. But generally speaking, I feel like most brokers don't want to get involved with a filing that they were not the original filer on to start with. So that's why I think it's really important for folks to get access to their own data and start running their own reports and start figuring out what they need to file. Because once you've got the data, it's relatively straightforward to file. My presentation maybe didn't show that today with all the different slides, but once you're able to do that, it's hopefully a relatively straightforward process. But yeah.
Great. And then another question from Abby. How are you characterizing the likelihood that seeking refunds could lead to compliance investigations from CBP?
It's possible. There are some clients that we have that are being very, very conservative with respect to how they submit CAPE claims because there's concerns over maybe a classification being incorrect, or maybe the country of origin was incorrectly declared on the original entries, or maybe they said they qualified for a free trade agreement, but they didn't. So there are these horror stories that we're hearing where, somebody submits a CAPE refund claim, and then customs says, okay, we will grant you the CAPE refund request, but now we realize that you misclassified your products. They should have been subject to Section 232, and you owe us money on the difference, right? Or we're going to deduct out the difference on the misclassification between the two codes that you used previously. My firm has been kind of taking this mindset that 2026 is really going to be the year of enforcement. I think 2025 was people trying to figure out what was up and what was down and what was happening. 2026, I think now customs has this they've increased their enforcement and their budget. There's going to be a lot more enforcement, but do I think that the filing of a CAPE claim in and of itself should create enforcement against you? I would say no, but you do probably want to do some due diligence and scrub your data and scrub your entries to say, hey, how were you doing this before you submit all of this additional data back to customs? Because there's definitely a difference between just, letting sleeping dogs lie or, asking for a refund back and asking customs to validate all of your data.
Great. And I know, Mark, you have to quickly jump on another call after this. We're almost at time, but I think this is a great question from the audience I definitely want us to touch on. And it's, would you advise that businesses who are paying tariff fees from vendors, should they change their terms and conditions on purchase order to reflect what they would expect refunds if they're subject to tariffs?
Yeah, I think if you are buying DDP, like downstream delivered duty paid from somebody, right? You're not the importer of record, and goods are just showing up at your location in the United States. Clear duty has been paid. You may want to just with the tariff environment being what it is, you may want to be crystal clear in your terms and conditions and supply agreements with them as to when you are entitled to a refund or when you are entitled to clawbacks from tariffs. The question, though, is going to be whether they agree to that, whether they have access to their own data, whether they, as the vendor, are filing for refunds properly. I mean, this is really where it gets kind of tricky, is because you have downstream customers saying, I want my refunds, but then the upstream importer is saying, well, I was the importer of record. I'm the one who paid the duties. And then sometimes those importers of record are going through the same process too, trying to figure out CAPE, trying to figure out protests, trying to figure out, do they need to go to court? Because if they don't do that, will they even have the funds to be able to refund them to anyone is the question.
Another layer of complication. Sounds like.
There's a lot to unpack.
Well, great. I think we'll wrap it up here since there's no more questions. I just have to say thank you so much to CEI, to Grace and Rachel. They did so much hard work to make this happen. And also, Mark, for your presence with this webinar. It was truly awesome having you here.
My pleasure. Thanks for having me.
Great.
Thank you. Have a good day, everyone.
Thanks, everyone.